Today, I'm thrilled to be joined by a repeat guest and always a favorite, Louise Ryder, who has many years of employment law experience, in particular with federal sector work. Today, we are going to be talking about the Report of Investigation, or the ROI, which is a big component of this.
An ROI, or Report of Investigation, is some agencies will call it the investigative record. It's essentially the summary of what has been compiled during the investigation stage or the formal complaint period. So essentially, the agency will have an EEO investigator, who can sometimes be an independent contractor, conducting an investigation where they'll get information from you, the complainant, and they'll get information from other witnesses, including the responsible management official. All of that information, what you have submitted and what the responsible management officials have submitted, is going to be included in the report of investigation. The report of investigation, it's usually structured where at the beginning it'll have the formal complaint that's been filed, as well as the documentation from the informal stage, meaning that the EEO counselor during the informal stage will write up a report. And that will outline when you've reached out to them, what claims you described to them during the informal stage, and some other matters like that. The formal complaint will then be included, as well as the acceptance letter. Essentially, that's where they indicate they accept your claims or reject them, and any objection you may have submitted will be included as well.
So you want to look at when they say you started the process and say, I don't have a lawyer at this stage. What else am I looking for in the ROI?
Well, you're going to want to look at the acceptance letters and make sure that any objection letter that you submitted is included. So that's something that, if it wasn't, that's something you're going to have to address down the road, because you want to be able to prove to the administrative judge at the EEOC, once you get there, that those claims that you raised them, you objected to their dismissal, and that those issues were previously addressed. And the other documents to look for are going to depend on what type of case it is. If it's a case involving a disciplinary action, a suspension or proposed demotion, removal, then you're going to want to make sure that what they have in there includes the proposed discipline, your response, and the decision, as well as all supporting documentation, because a proposed disciplinary action should have all the supporting documentation with it. And you're going to want to make sure that that's in the record if you're dealing with a disciplinary action. If you're dealing with a non-selection action, there are very specific documents, probably more so than any other type of case, that you want to make sure you look for.